Thank you for coming, by the way. This is great. Your stardom has been advanced here. Everybody was excited today. You had probably the largest crowd we've ever had for a Robert H. Jackson lecture, and certainly the largest to stay around.
Well, excellent.
Yeah. So welcome. Your first time to Chautauqua. What's your impressions of all this?
Well, I'd been hearing about Chautauqua for years when I was growing up because my grandmother and her first cousin came every summer. And so I was excited to get a chance to come up. And when I arrived, I was just struck by how incredibly gorgeous Chautauqua is. A combination of just physical gorgeousness and total charm. You know, the houses and the people walking around and everything was just, it's just been delightful.
We hope you come back.
Well, I hope to come back.
Was law part of your life? Was your mom and dad, were they into this at all?
No, I'm the first lawyer in the family. I mean, my grandmother's brother-in-law was a lawyer, but I didn't spend much time with him. I actually decided to become a lawyer because when I was a junior in high school, over that summer I read Simple Justice, which is a book by Richard Kluger about the litigation that led up to Brown against Board of Education. Mm-hmm. And I decided I wanted to be a civil rights lawyer and work for the NAACP Legal Defense Fund. So that book inspired me to become a lawyer. And as you probably know, there's a long discussion in that book about Justice Jackson and his then law clerk, William Rehnquist, and the famous or now infamous memorandum from Justice Jackson from Justice Rehnquist.
As you went through that Kluger book and you read about the activities of Thurgood Marshall and William Coleman and the whole cadre of people who were working on the case, did that inspire you to the extent that you could find that that's a lineage that you could have carried on here?
Yeah, well, I decided I wanted to work for the NAACP Legal Defense Fund, which is the organization that Bill Coleman and Charlie Black and Lou Pollack and Thurgood Marshall and Jack Greenberg were all part of. And in fact, that's what I did do. When I was in law school, I worked there for each of the summers I was in law school. And then I was a staff lawyer there for several years before I went into teaching. And I still continue to work with them on cases. So I like to think of myself as being part of the extended Legal Defense Fund family.
Did you ever catch up with any of those icons along the way? Some of them many are still alive.
Oh yes, absolutely. So I knew Jack Greenberg quite well. I knew Bill Coleman, who was chairman of the board of the Legal Defense Fund by the time I was a lawyer there, quite well. I met Thurgood Marshall when I was clerking at the Supreme Court. I knew Constance Baker Motley from when I was clerking at the District Court in New York. She was the chief judge when I was clerking on that court. And Bob Carter I knew just from, hanging around with civil rights lawyers. So I think of all of the people who were still alive who had argued in Brown by the time I was an adult, I managed to meet them all. I mean, all of the people who argued on the right side.
Yeah. Did you find that with that, did you find that you went to law school, and were there a lot of your classmates who found that social part of the practice of law important?
Well, I think, I have a lot of friends from law school who have done public interest practice, or either for private groups like the Legal Defense Fund or for the government. So yeah, I think a fair number of the people I knew in law school were very committed to doing civil rights work and have done it in one form or another throughout their careers.
Constitutional law, of all that, was that the area which you've obviously established a reputation?
Well, the kind of irony about that is when I got to law school, my first semester in law school, I was assigned to constitutional law with Robert Bork. So I'm not sure that what I learned in first year constitutional law stuck. I knew I disagreed with him, and I didn't really know why I disagreed with him, because I think for me the difficulty in the way he taught is he was very fast, very quick, very witty. And you're a first-year law student, and so even if you know you disagree with him, it's hard to formulate what your disagreements are. And I think I didn't teach constitutional law until I'd been teaching for quite some time, in part because I didn't want to have my students experience constitutional law in the way I had experienced it, as the professor having a very strong point of view that kind of overwhelmed whatever values you came into law school with. So I've always tried to be very careful that I teach my conservative students how to be the best constitutional law lawyers they can be, as well as teaching students whose views on the issues coincide more with mine.
The pinnacle of constitutional law argument and discussion is, of course, finding yourself in front of the United States Supreme Court. Day one, when you walked in there and you presented your case, how were you feeling?
Well, this is going to sound odd, but I actually felt more comfortable arguing in the U.S. Supreme Court than I felt arguing in several of the courts of appeals where I've argued, in part because I clerked at the court. And so the building was familiar to me, the personnel on the court were familiar to me. You don't have the problem when you go to the Supreme Court that you can have on courts of appeals, which is you don't know who your panel is until you get there. So you've thought about, you've briefed the case for the people you're actually going to argue in front of. The thing that's amazing about the argument is how fast it goes. I mean, my first argument, I only had 10 minutes because I was splitting time with the Solicitor General. And I felt like I didn't take a breath the whole time I was up there. It just whooshed by me. But there's something totally exhilarating. I sometimes say to my students that arguing in front of the Supreme Court is the most fun you can have in 30 minutes in public, wearing your clothes, standing up, being all by yourself, doing nothing but talking. And I continue to feel that, although I have to say that the current court is so much more conservative than both the court I clerked on and the court I started practicing in front of. That it's a little less fun to go up there today because it's a little harder to win the cases that I tend to be arguing.
You were clerk for Justice Blackmun, and what was your term?
I clerked for Justice Blackmun in October term 1985, so it was the last year that Chief Justice Berger was Chief Justice.
Well, go through and tell me a little bit about each of the justices of that, or maybe a vignette, something.
Sure. So I'll do them in order of seniority, because when Justice Blackmun used to come back from the conference where it's just the 9 justices in the room and nobody else, he would read us his notes, and he always read them in the order the justices went, which is the order of seniority. So Chief Justice Berger, he looked like a Chief Justice. He really did. By the time I got there, Justice Blackmun and he, although they had been friends growing up, and Justice Blackmun had actually been the best man at Chief Justice Berger's wedding, by the time I got there, they really weren't speaking to each other. And so I think my views of the chief are colored somewhat by how Justice Blackmun felt about him. But the chief was very into ceremony. He was fairly conservative, not super imaginative. My first encounter with him was there was a party at the beginning of the term for all of the clerks in the justices' dining room. And he came up to me and he looked at me, and I had been talking to Justice Rehnquist, and he looked at me and he said, "Well, there certainly are a lot of you here this year." And my first reaction is, how does he know I'm Jewish? But he actually meant women, because there were 7 women. And so I said, I realized that's what he meant. And I said, well, you know, Justice Blackmun has 3 female clerks this year, and it was the first time a justice had 3. And the Chief Justice looked at me and said, well, I guess he's going to need a lot of help, huh? And I said, no, we're going to do all the cooking and cleaning ourselves. So my experience with the Chief was somewhat odd. Justice Brennan was the senior associate justice at the time, and he was extremely gregarious and outgoing. So he would, you know, how are you, he would say, and he had that kind of New Jersey accent. The other thing he taught me, I think this is one of the things I've never forgotten, is he taught me how, if you have to shake a lot of people's hands, to shake hands with them, which is you extend your hand and then you grab their elbow, because then if they squeeze your hand too hard, you can squeeze their elbow and they'll release their grip. And he told me he learned that in politics. He was very gregarious. He was, he made an effort, I think, and I think it was a strategic effort in addition to just his natural outgoing personality, to get to know a lot of the clerks in the building, because I think he felt that that helped him to enlist them kind of on his side in a way. Justice White was
Kind of a later Frankfurter type person?
Um,
What I read about Frankfurter, sort of.
yeah, I think in a way. I think in a way. Justice Frankfurter, I'm sorry, Justice White was the second most senior associate justice. He had given up playing basketball with the clerks by the time I was there. Apparently, a couple of years before, a clerk who had been just frustrated by the justices' somewhat over-rough play had just cold-cocked him during a game. But he still putted with his clerks for money every afternoon. It was interesting, my year at the courts, the division among the justices, the thing that most seemed to divide them was there were a couple of abortion cases and Lawrence against Texas, which was a case about the Georgia sodomy, I'm sorry, not Lawrence against Texas, Bowers against Hardwick, which was a case about the Georgia sodomy statute, which was ultimately overruled by the Supreme Court later in Lawrence against Texas. And so there was a little bit of tension between Justice Blackmun and Justice White because they were on opposite sides of those two cases. The next justice down was Justice Marshall. And by the time I got to the Supreme Court, he was quite old. I mean, there were 5 of the justices were over 75 the year I was there. He was quite old. He wasn't in the best of health. And so he moved very slowly, and I think he was kind of angry and alienated by then quite a bit from the court. But occasionally, if you stopped by his chambers in the afternoon, he would be in a storytelling mood, and he was a marvelous storyteller, so he'd tell stories about his time in practice. I think he was obviously one of the most formative lawyers of the 20th century. But I think he's one of those people, if you were writing his biography, most of the good stuff happened before he got to the Supreme Court, as opposed to some of the justices for whom the Supreme Court really was the pinnacle of their achievement. Then there was Justice Blackmun. Turn back to him because I'm sure you have more specific questions about him. Then came Justice Powell. Justice Powell had been sick the year before and had been out for quite some time, and was still a little frail when I got there, but and kind of extraordinarily gentlemanly. One of the clerks my year had a serious medical issue, and Justice Powell sent flowers to the clerk afterwards. Just a charming man. He switched his vote in one of the biggest cases my year, Bowers against Hardwick, and I think Justice Blackmun was convinced the chief had lobbied him very hard on that case. He was the swing vote when I was there, and so on a lot of issues. So there was a lot of concentration on him. After him came Justice Stevens. Justice Rehnquist came, and then Justice Stevens. And Justice Rehnquist, when he was an associate justice, I think was a little bit looser than he was when he was Chief Justice. Although the interesting thing for me is when I went back to visit Justice Blackmun after Justice Rehnquist had taken over and became Chief Justice Rehnquist, everybody loved him as Chief Justice. He was thought to be extremely fair and balanced and straightforward in a way that I think the liberal justices had not felt about Chief Justice Berger. But when I was there, he was still a relatively junior justice. He was quite often in dissent, much more so than when he became Chief Justice, but very friendly, very casual. His clerks were out of the building by 6 p.m. We were there till midnight. Then after him came Justice Stevens, who was exactly the same, interestingly quirky, and always in a bow tie. He only had 2 clerks. The other justices all had 4. And it was very much kind of his own person. Mm-hmm. And then came Justice O'Connor, who was very junior, obviously, when I was there. She was in her, I guess, her 4th or 5th term on the court. And, extremely personable. She ran a exercise class for all the female clerks at 8 a.m., and we were invited to go to it, but unfortunately Justice Blackmun had breakfast with all of his clerks at 8 a.m., so I think we managed to get to the exercise class 2 or 3 days when he was out of town, but other than that, we didn't go.
Justice Blackmun wrote to me one of the most interesting decisions in Flood versus Coop,
Oh, yeah,
baseball.
yeah.
Do you guys ever have any reason to talk about that?
Well, yes, so I think it would have been Justice Blackmun's, it might have been his 80th birthday, but it was one of his big birthdays. We were having a clerks reunion, and as you know, in Flood against Kuhn, which is the baseball antitrust case, there's this kind of passage at the beginning of it that's a list of famous baseball players, and it goes on and on. And apparently he started out with about 10 of them. Then various people around the building would suggest people, and then somebody said, well, but if you're going to include, if you're going to include Tinkers, you have to include Evers. Oh, if you're going to include Evers, you have to include Chance. And so that list kind of expanded and expanded. And there was a story in the Brethren that right after the opinion came down, somebody said to him, how could you not include Jimmy Fox? And he said, Jimmy Fox was on the list. And the person said, no, he's not. And the justice went back and looked at the list, and sure enough, Jimmy Fox is not on the list. And the line in the Brethren is something like, and Justice Biden said, I'll never forgive myself. So for his 80th birthday, I think it was his 80th, we decided we were going to get him one of Jimmy Fox's bats. And we looked into it, and we could not find one. But it turns out that Hillrich and Bradley, I think that's what the Louisville Slugger Company's name is, they keep the measurements of every player on file for their bats. And so we went to them, and we had them replicate one of Jimmy Fox's bats, and we had it mounted on a plaque, and on the bottom it just said, I will never forgive myself, H-A-B. And we gave it to him, the clerks all gave it to him for his birthday, and I saw it actually posted in his chambers the day he died. After his funeral, we all went back to the chambers to hang out, and there was the bat, which I think was, several people asked for it, but I think it was given to the Library of Congress. And the other thing about baseball is he had been a friend of the Griffiths, who owned then the Minneapolis Millers, later the Twins, and so we would talk about baseball a lot at breakfast, and one day in the afternoon, I was in the upstairs chambers, and I got a phone call, you should come down, the justice has somebody he wants you to meet. And this group called the Emil Verbin Society was having its reunion in Washington. I guess it's a Cubs thing. And so there were these 3 guys in like bad fitting sports coats in his office, and he introduced them to me, and 2 of them I don't remember the names because I'm not a Cubs fan at all, but the last one was Andy Pafko, who had been a Dodger as well. And so I had a nice conversation one afternoon with Andy Pafko. And the last baseball thing I'll tell you is when Justice Blackmun retired from the Supreme Court, I was asked to do one of the tributes for him in the Harvard Law Review. And one of the things I talked about in the tribute was this article that had been written called Your Law Baseball Quiz. I think I told you about this last night, where they compare different justices to different famous baseball players. And I said that, and so I tell the story of, Jackie Jensen is like Byron White because they were both better at football. And then I say, the guy who did this compared Felix Frankfurter to, among other things, Wayne Terwilliger. And in the article I just had a footnote, I said, who is Wayne Terwilliger? And so, and then ultimately I said that if I had to pick somebody for Justice Blackmun to be like, I had thought originally about Bobby Brown, because Justice Blackmun wanted to be a doctor, just like Bobby Brown became a doctor. And that I thought of, a couple of other people like that, Charlie Gehringer, because he was a little tiny, little tiny second baseman, and, a great fielder, but not a big batter. And ultimately I came out with Dave Winfield, which people might not have guessed, because both of them came from St. Paul and made something of themselves. Both of them played the game long after many of their contemporaries had retired, and both of them owed their start to a convicted but later pardoned Watergate felon. To a later pardoned Watergate felon, because Blackmun got his seat on the Supreme Court from Nixon, and George Steinbrenner is the person who gave Dave Winfield his biggest contract. And so when I read this, and I went, and the next time I visited the justice said, "Oh, I really liked your tribute a lot, but come with me." And he led me down the hall into the storeroom. He was then down at the Thurgood Marshall Center,
and he pulled out a copy of the baseball encyclopedia, and he said, "This is Wayne Terwilliger," and took me to the page for Wayne Terwilliger. So
Twig. He was known as.
I'd never heard of him, and I'm a baseball fan, and I'd never heard of him.
In fact, I think until a few years ago, he was still in baseball as a coach. Did he ever talk about Roe versus Wade, you guys?
Yeah, so the first time he talked about Roe versus Wade is when I went to interview with him. He had Justice Blackmun had been a tax lawyer before he was then counsel at the Mayo Clinic, and he had exactly the habits you would expect from somebody who had been a very good tax lawyer. He was like incredibly meticulous and precise. And so when he interviewed people, he had this long list of questions written out, and he asked you the questions, then he wrote down the answers in pencil. And towards the end of the interview, he said, "Now, I want to ask you a question, and I want you to think about this very carefully." So I was there, and then he said, "Now, I've written an opinion that's a little bit controversial, and some people find it the kind of opinion that they have trouble with, and you need to think about whether you would be comfortable working for me given the opinion." And I'm sort of racking my brain to think, like, what opinion is he talking about? And he said, "You may have heard of it." And now I'm thinking, okay, what is he going to say? He said, "It's called Roe against Wade." And, you know, I'm a little bit of a kind of smartass sometimes, and all I could think is, just don't say, "Oh my God, you're that Harry Blackmun? You're kidding." But he actually had a clerk apparently several years before who had, in the middle of the year, had a religious revelation that Roe was wrong, and it had made for an awkward year. So that was the first time that I had a conversation with him. We had 2 abortion cases my year at the Supreme Court, and it's actually the kind of high watermark of abortion rights at the Supreme Court was one of those cases, a case called Thornburg against American College of Obstetricians and Gynecologists, which the justice wrote. And so we had a fair number of conversations about abortion, and he was convinced that, you know, that was also the first time that it was 5-4 to uphold the kind of central premise of Roe, because the Chief Justice switched sides. So we talked about a lot then, and then as you probably know, he used to teach at the Aspen Institute in the summer, a Justice and Society class, and he spent a day of that talking about the decision process leading up to Roe, and I was there one year. He talked about that there.
What did he say?
Well, he taught, I mean, it's interesting. I think, although he wouldn't put it quite this way, his thoughts about Roe evolved somewhat over time. Because when he started on the case, his major, the major focus for him was the practice of medicine, because he had come out of being counsel at the Mayo Clinic, and he took very seriously the idea that this was a medical procedure, and therefore it was up to women in consultation with their doctors to make this decision in the way that would be true of all other medical procedures. I think over time he came to see Roe as equally about women's autonomy, that it wasn't mostly about medical autonomy, it was about women's autonomy. And by the time I got there, I think he was thinking about it in those two things were much more in equipoise in being important to him. But he just thought it was not the kind of decision that should be made categorically by the state as opposed to by individuals given the circumstances they found themselves in.
Had Jane Rose publicly switched positions by then?
No. I think she had said by then that she regretted having had the abortion, but it wasn't until maybe about 5 years ago or so that she filed a sort of coram nobis trying to get Roe overturned.
If you had this pause and say, all right, Greg, I've been involved in this constitutional law business for since 80s, and you had to pick kind of the 5 seminal cases to teach a master's class, which 5 would you pick?
5 cases since the 1980s?
Yeah, since you started. I mean, I'm
okay.
doing a little baseline when you entered into the Supreme Court.
So if I had to pick the cases since I started, well, you'd have to teach District of Columbia against Heller, the Second Amendment case, in part because it's it's like a kind of kaleidoscope of all the different methods of constitutional interpretation. It's got a little bit of originalism, a little bit of textualism, some pragmatic consequentialism, a little bit of the structure, constitutional structural reasoning. And so, although I'm not sure that the opinion has big legs, that is, I'm not sure that there's going to be a lot of laws struck down that would have otherwise been upheld, or the like. It's a real window into contemporary constitutional law. So I definitely teach that. I think I would teach Lawrence against Texas, because for substantive due process cases, it's one of the most interesting ones, and you can see echoes of all of the sort of different prior cases in it. I would definitely teach the Affordable Care Act case, because it reviews huge amounts of constitutional law up till then, and it sets down some markers for the future. I'd have to teach one of the race cases, on the question of which race case to teach. You know, on the one hand, Grutter is very important, but I think maybe parents involved against Seattle School District Number 1 is more significant, because there's more of a discussion of what the meaning of Brown is for modern times, and it's more the contemporary court. And then, I mean, there are a lot of different candidates, because it depends on what you're trying to do in the master class. That is, if you're trying to say which cases have had the most impact on everyday people's lives, that's going to be a different question than if you're sort of saying which cases give you the greatest insight into kind of how the justices think about things. And
Today at the presentation, you gave wonderful, a wonderful conversation with Jackson and current issues, which is, of course, the Jackson mission here is to create the relevancy of Justice Jackson today.
Yeah.
And you did a phenomenal job of doing just that.
Well, and I didn't mention one of the ones where he's been most influential, because it was a lay audience, which is the steel seizure, the kind of three-part framework for determining the relationship between executive power, legislative power, and constitutionality. But I thought to try and do that with a lay audience would be almost impossible.
A few years ago, John created an event at Albany Law School, and Phil Neal, former University of Chicago dean, and also a co-author, said if there's one thing that probably needs to be done in law schools, is somebody ought to teach Jackson, and specifically his ability to write, his style, and also take it one step further, which is what you did today. Is that realistic?
Well, I mean, I could see teaching a seminar. It would be a great seminar to teach one justice through a range of cases. I mean, I've often, so I have a friend who's also a law professor who once suggested you should teach a course called something like 342 U.S., and the casebook for the course would simply be that volume of U.S. reports. Because I find that you can often see really interesting relationships between cases that don't look like they're about the same thing, but that are decided around the same time. So I think it'd be wonderful to have a course that focused on a single justice. I mean, you'd want it obviously to be an advanced common law class, or an advanced law class more generally, so that it might also involve statutory interpretation as well as constitutional interpretation. But I think the chance to read the unexcerpted decisions of a particular justice, so you actually get a sense of what an opinion looks like, as opposed to what's in the casebook, which is a little bit of facts and then boom into the money language. Yeah, it'd be a great thing to do.
You've accomplished so much so far. As you look in the crystal ball for the next 5 years for Pam Karlan, are there books you want to write? Are there positions you'd like to get? Is there the ambitions of Pam Karlan?
Well, one of my ambitions is to be a better teacher. I love teaching. I love both the clinical teaching and the regular teaching. A little bit of it is also, you know, after you've done any particular thing for a while, you're always looking for a little something new to do. So for a while, I was concentrating almost entirely on election law stuff. And now for the last 6 or 7 years, my primary focus has been this clinic that litigates cases at the Supreme Court. So I'm always thinking, like, maybe it's around time to figure out what the next thing is. I don't have, you know, ambitions to change my life permanently in some way. I'd like to spend some time working at the Department of Justice, I think, you know, if the right job came along at the right time. And it's always one of these questions of timing and job and the like. I mean, I was offered, the job that I would now like to have, I was offered in the Clinton administration, but it was the wrong time.
Mm-hmm.
I was changing schools at that point, and I'm single, and, you know, I didn't want to take 2 years, it's kind of a 2-year detour, but as you get older, it seems less of a detour and more of an opportunity just to serve and then to go back to being just a country law professor.
Okay, so President Obama gets reelected. Ruth Bader Ginsburg resigns. Who were the top 3 candidates?
Well, to figure out who the top 3 candidates are, you would need to know what year she resigns in and what the Senate looks like. Because if the Democrats have control of the Senate, you'll see a different nominee than if the Republicans have control of the Senate. Some of it depends on, you know, people can kind of shoot out of nowhere in various ways. You know, Elena Kagan was the first justice in probably, 20 years to be, since Justice Rehnquist and Justice Powell was the first justice to go on the Supreme Court not coming out of an appellate court. I mean, Justice O'Connor was a state court, and to be really accurate, Justice Souter was mostly a state court judge. He'd only been on the First Circuit for less than a year. But that's a different kind of pick, and so it'd be interesting to see whether the president decides to think about somebody who's held elective office. I mean, that was one of the points I was making in my lecture today over at the institution, is that we don't have anybody on the Supreme Court with real nitty-gritty running for office experience. So I could see somebody like Jennifer Granholm or Lisa Madigan, who's Attorney General of Illinois, or Kamala Harris, who's Attorney General of California. You know, the president hasn't put a lot of women on the federal courts of appeals yet. Mm-hmm. So if that's where you're looking, you know, it's not clear that there's a deep bench of Democrats there. If it's a Republican Senate, he's going to have to move considerably towards the middle. It's very hard to know.
Well, let's assume it's all Republican. George Romney, it's Republican.
Mitt Romney. George Romney
I'm dating myself because that's George.
Is no more.
I was a stockholder of American Motors Corporation. I just want you to know that. That's how far back I go. And Detroit Tigers fan. So to put that all in perspective. And Mitt Romney. So it's full Republican, and he's got the choice. There are 2 or 3 candidates that jump out at you as logical.
Yeah, so I would think for him the kind of obvious choices would be Brett Kavanaugh, who's on the D.C. Circuit, very young, very conservative. Jeff Sutton from the Sixth Circuit, young and conservative and smart, although Jeff probably didn't do himself a big favor when he upheld the Affordable Care Act. And then I would think Paul Clement, who's the Solicitor General, would be in the Bush administration, be a kind of obvious candidate. Those strike me as the people most likely in a Romney administration.
I'm smiling because Dahlia Lithwick answered the same question the same way.
Well, paranoid liberal
Though
minds
she had
think
a
alike.
couple of male names to the Democratic list.
Oh yeah, I mean, I could name some. I mean, Judge Garland would be, you know, if it's in the next year or two, who's on the D.C. Circuit, would be a kind of obvious candidate. You know, now that Paul Watford has gotten onto the Ninth Circuit, he might be an extremely attractive candidate.
Most important question.
Yeah.
Should baseball retain its antitrust exemption?
Well, I'm a big Bill James fan, and Bill James has a discussion of this where he says that if you got rid of the antitrust exemption, what you might start to see is a kind of proliferation of a third or fourth major league almost coming out of minor league teams. I'm not sure what function the antitrust exemption really performs today, given that there's now an agreement between the Players Association and the teams, right? And a huge percentage, ever since free agency, a huge percentage of the revenue has moved over to the players. I'm not sure that the existing players would favor getting rid of the antitrust exemption.
Such an anachronism.
Yeah, but hard to see that it's actually having much effect on the game itself. And the real question is how you maintain competitive balance, right? If you want to maintain the sport, the real question is how to maintain competitive balance. And without the antitrust exemption, it might be harder rather than easier.
Supreme Court Historical Society is celebrating the 40th anniversary of that decision, and they have working with two podium individuals and a judge to sort of reenact the case, not simply take it. I don't know if you're familiar with that, but
Right.
Have they approached you at all as far as any guidance?
No. Flood Against Kuhn was way before my time.
But you're a baseball person.
I know. But every time I say something critical about the Chief Justice and being an umpire, I think I diminish my chances of being invited to the Flood Against Kuhn celebration. I'll never forgive myself.
Well, tell me about that.
What?
You wrote that. Did you get feedback? Did you get
What?
blowback?
The Chief Justice doesn't blow back. But,
But did somebody? There's allies.
No. I mean, I was at an event where I talked about this, and this may be kind of amusing. So I was at an event where I talked about this a little bit about the Chief Justice and the umpire analogy and the like. And afterwards, Justice Thomas had been there, and he came up to me and said, "Can I give you a little advice, Pam?" And I said, "Oh yeah, sure, Mr. Justice." He said, "Don't hold back. Tell us what you really think. You've got to stop being so reticent." So, no, the Chief Justice is a big boy.
Yeah. By the way, John talked about Clarence. I've been in social situations where he's been there, and by far and away, when all the justices are there at a Supreme Court Historical Society event,
Well, he's very outgoing.
you can get immediate access to everybody but him.
Who?
Only because he's got 40, 50 people hanging around him.
Ah.
I mean, it's just not that you can't get to him.
Yeah.
It's
No,
just-
he's got more social skills in one-on-one than the average Supreme Court justice.
Absolutely. He's slapping more people on the back, telling more stories, and
Yeah.
he's amazing. Of the current justices, and you've written about them. What's your sense of Roberts' decision? I mean, how do you read that in the Health Care Act? I don't want to say Obamacare because you don't want me to say that, but
Well,
crawl into his head.
I mean, I don't want to crawl into his head. I was not surprised at all by most of what he wrote. That is, I was not surprised that he upheld it on taxing power grounds. And I was not surprised that he thought there was a spending clause problem with Medicaid, because those seem to me to be pretty predictable. What did surprise me is how much he went out of his way to decide the Commerce Clause issue when it wasn't necessary to the bottom line, because as you know, he spent a lot of time talking about how we should do not decide the things we don't need to decide, and then in this case he went out of his way to do it. And he's done that before. That is his opinion for the court in the Namudno case, which is a case about the constitutionality of Section 5 of the Voting Rights Act. The court ultimately decided it on very narrow statutory grounds, but along the way, he said a lot of nasty things about the Voting Rights Act. He was a clerk for Justice Rehnquist and observed Justice Rehnquist's Supreme Court career. He is a huge fan of Chief Justice John Marshall and has thought a lot about John Marshall's career. And both of those men, both Marshall and Rehnquist, were extremely strategic and kept their eye on the long view. And that's true for the Chief Justice as well. The man is 57 years old. He does not need to take all the cards off the table in one hand. And I think his decision, his opinion in the Affordable Care Act case was an extremely strategic decision.
So that somebody on all sides could, if they, once they read it with fine glass, they can get something out of that.
Well, it's designed to make him appear statesmanlike, right? Which is, he sort of says, look, there's this passage towards the beginning of his opinion where he says, it's not our job to save the people from the consequences of their political decisions. Our job is to apply the law. Well, what is that supposed to mean? And not our job to save the people from the consequences of their political decisions. In other words, saying, if you pass a stupid statute like this, don't expect us to fix it. So I think it was designed to make him appear non-political, right? He's turning his back on the Tea Party agenda in this case, while also allowing him to say a bunch of nasty things about the kind of liberal welfare state. And I think he gained a fair amount of capital from the decision there that will stand him in good stead when he spends it on issues he cares more about. I don't think the Commerce Clause is the biggest issue for the Chief Justice that he cares about in constitutional law. I certainly don't think the taxing power is.
Robert Jackson Center, you're here today. We're thrilled you are here today. And we are here to advance the legacy of Justice Robert Jackson. I had Michael Berenbaum, who you met, sitting in that seat just yesterday, asking him, if he had some advice for us, because we're only 11 years old, we're a work in progress, as to areas of which to find ourselves in. If you had to give us some guidance, Pam, what would you do?
Well, if you think about Justice Jackson, right, what are the kind of things he's most known for? The Nuremberg trials, which obviously have continued bearing on the world today because of the rise of international war crimes tribunals and human rights tribunals and the like. I mean, obviously, that's one area where he serves as a kind of focal point for the United States on that. And then the other thing I think is legal writing. To go back to the point you were making about Phil Neal earlier, that Justice Jackson was such a clear writer and thinker. I think it'd just be really useful to think about how do you perpetuate that legacy. I mean, you can read a Robert Jackson opinion today and it speaks to you. Whereas, you read some of the opinions from the Warren, Berger, Rehnquist, and Roberts courts, and they're just impenetrable. Or they're impenetrable sort of masses of soupy mass with a couple of quotable lines thrown in. And the thing that's interesting, and made it a little hard when I was preparing my talk for today for the Jackson Center is sometimes the best Jackson quotations are 2 or 3 paragraphs long because he's setting up an argument and then explaining the argument as he goes through it. I mean, even though he's got some of the greatest one-liners in Supreme Court history, that's not actually what makes him the greatest writer in some ways. And so getting people to focus more on legal writing.
How would you do that?
Boy, that's an interesting question. I mean, I think it'd be great to have something that gives people a sense of how good his writing was. Some of it depends on which audiences you're aiming at. I mean, I think having a legal writing thing where you bring in judges and talk to them about legal writing. I mean, especially like state Supreme Court justices often don't get much training in how to write an opinion or how to think about it. And I think that would be a really interesting thing to do.
What did Harry Blackmun mean to Pam Karlan?
He was just such a great boss, right? And he was so meticulous. I mean, one of the things that he really taught me was attention to detail. I mean, because he was very much a detail man, and just an extremely brave man. I mean, the year before I clerked for the summer that I clerked from, the year that previous spring, when he came back to start eating breakfast with us, we had a U.S. Marshal with us, a Supreme Court police officer with us every morning at breakfast. And the reason for that is that he had been shot at the year before. He got up to go to the kitchen, and a bullet came through the window and landed in the chair he'd been sitting in. One of the things he then ended up with was a huge kerfuffle with his insurance company because there was a pair of upholstered chairs, and the FBI came and cut out a huge chunk of the chair that the bullet had gone into, and he wanted to have both chairs recovered, and the insurance company said, well, there's nothing wrong with the other chair. So there was a bit of a back and forth over the chairs, but he was very principled. He stuck to his principles, and he was unbelievably hard working. I mean, however hard I work, I never work as hard as he worked.
You're the 8th speaker in the Robert H. Jackson lectureship, and you've raised the bar very, very high, Pam, today.
So how lucky that you're doing that mambo thing and everybody can get under it more easily now.
Well, who would you recommend to John and I for next year?
Oh, so thinking about
We've had former solicitor.
Yeah, so I'm thinking about who is it that I love to listen to when they talk about law that you haven't had, because you've had Paul Clement come, right? Mm-hmm. Yeah, and you've had Dahlia, who I love listening to. I'm just thinking, who are other people that I just can't get enough? Bill Marshall is a really interesting guy too. I find him just really interesting to listen to. In terms of one person who'd be interesting to have, because he's now off the bench and he's talking a lot more frankly about a lot of stuff, is Vaughn Walker, who was a federal district judge in California, who's a really interesting speaker and obviously decided a huge number of important cases, including the California marriage case. I would think he'd be super interesting. Just kind of thinking. My colleague Michael McConnell is a super interesting speaker on virtually everything. One person, because I think, who might be really interesting is Cheryl Eiffel, who's a professor at the University of Maryland, who is writing right now about judicial confirmation processes. And she's an unbelievably great and dynamic speaker. So she might be a good person.
I should show you the clip of Dahlia talking about you.
I love Dahlia. She is so interesting. She wrote a piece this past year that was my favorite piece of all time about corporate personhood. It was about this little nothing burger case called I think it was FCC against AT&T. It was a case about an exemption under the Freedom of Information Act for things that would interfere with the personal privacy of an individual, and AT&T said, well, we should be able to protect ourselves here, and the court ultimately held that they shouldn't, and the Chief Justice makes some jokes about AT&T and not taking anything personally in his opinion. But she wrote a description of the oral argument in the case that was written completely as if AT&T were a person, and it's just marvelous.
Question that is often asked.
Oh no, who you should definitely also think about is Walter Dellinger, who is a great speaker, and was not on the court during the Robert Jackson years, but was a Hugo Black clerk in the 1960s.
A question that gets often asked by our local radio guy is, if you had a chance to have dinner, aside from John, Jim, and I, anybody in history, and you could choose 3 guests, who would that be? It doesn't have to be law related. Just somebody who you'll find just extremely fascinating to read about.
That's such a hard question, because who you want to have dinner with is somebody who will actually talk to you about that stuff, as opposed to somebody who won't talk about it, right? So you might be really interested in knowing what somebody thinks, but if they're very guarded, then the dinner would be kind of painful, so.
You're overthinking this.
No, I know, but I'm a law professor. So I would really love to have dinner with Franklin Roosevelt. I would really love to have dinner with Franklin Roosevelt. And although I think I would have to like be extremely careful and sit at the other end of the table, I'd actually love to have dinner with Lyndon Johnson.
Mhm.
I was just reading the last of the volume, most recent of the volumes of the Caro biography. I'm just fascinated by him. And I just, I'd love to, and the other person I would love to have dinner with, because I would just love to know more about what made her who she was, is Fannie Lou Hamer.
Hmm.
I mean, where did you get the kind of courage to stick with it like that? And,
Just as an aside, I recently interviewed Andrew Young, and I gave him flashcards of
Yeah.
all the people in the civil rights movement. And I had 20 minutes to talk to him, that's all I had. And I gave it to him as like baseball cards.
yeah.
And just tell me, who are these
Backs
people?
left, throws even further left.
Yeah. Who are these people?
Yeah.
From Roy Abernathy. But anyways, he got
Yeah.
the Fannie Lou, and he just lit right up.
Oh, yeah, I mean, she's a total hero. She's a total hero of mine.
Yeah.
She's a total hero of mine.
This is great.
Oh,
You
thank you.
are terrific. And
thanks.
now unfortunately, you have dinner with just the three of us.
I'm looking forward to it. What's the line about, you can summarize every Jewish holiday in 9 words? They tried to kill us, they didn't, let's eat.
Cindy just texted, she's going to the restaurant.
Then she's tagging along too, because you got the word out.
Right. So, the 5 of us, I guess, right?
Okay. We're going to
Somebody
the,
else?
pardon?
You're coming for dinner? Yes. Or are you going home?
Oh, excellent.
We're going to the Italian Fisherman.
You're going, okay. Okay, good. So that'll be
6. Yep, okay, perfect.